Hi, good afternoon. I'm going to present on the case study of ANZ versus ACC, Australian Competition and Consumer Commission. My group is YESFO_38, and my name is Ashok, and I'm going to present on behalf of my group member. So our topic is focused on the price fixing issues. Why were the ANZ and the directors not liable for the price fixing? Which directors' duties under the Corporation Act are breached if the company engaged in price fixing? And Accc versus Flight Centre Travel Group Limited. So first of all, as we know, Accc is the Australian Competition and Consumer Commission, which is the independent authority of the Australian government in 1995. The main job of Accc is to monitor and protect the business rights and obligations of consumer rights and prevent illegal anti-competitive behaviors. And as we all know, the ANZ is the Bank of Australia and New Zealand Banking Group Limited. So first of all, I would like to start what was the case all about. The case was related to the ANZ, which that the mortgages refunds agree to limit the refund amount for the customer in respect of arranging the ANZ home loans. Australia and New Zealand Banking Group Limited is providing the mortgages loans to the customer through the internet and external channels. The mortgages refunds are independent from which is engaged in the distribution of mortgages of ANZs. The mortgages refunds are offering to refund the customer from some part of its commission. Its mortgages are approved by the ANZ. The Accc has the main claim that the ANZ is providing the loan arrangement facility to its customer internally. So Accc had filed two cases of the price fixing. One was against the Flight Centre and another was against the ANZ. In the cases related to the Flight Centre, the Australian Competition and Consumer Commission alleged that the Flight Centre entered into the contract with three airlines, maintained the price for the air travel. The report described the details and the facts of the cases, the duties breached by the ANZ, the decision of the full federal court, and the reasons behind the decision. So Acc's main aim is to avoid the anti-competition arrangements. As per Acc's claim, the ANZ was trying to do the price fixing. The claim of Accc was the banking group made an agreement. Banking group had made the agreement that it was going to only allow the mortgages refunds offer in Australia and New Zealand Banking Group Limited mortgages products if the mortgages refund agreed on the terms and the conditions of Australia and the New Zealand Banking Group Limited. The terms and conditions include the mortgage refund was required to limit the amount of refund to its customer to $600 for the arrangement of the loans, the services, and it will allow the Australia and New Zealand Banking Group Limited branches to match the deal if they choose to waive the Australia and New Zealand Banking Group Limited loan establishment fee. Mortgages refunds and Australia and New Zealand Banking Group Limited were the competitors in the market for the provisions of services related to the loan provision. So when this matter went to the court, the court has dismissed this case, and the decision was in the favor of ANZ. As according to the court said that the competition can be possible in the internal and external distribution channels. The court also ordered that Acc's priority is to avoid the anti-competitive practices and agreements because impending the competition damages the business and the consumers, that is harmful for the entire economy. The Australian Competition and Consumer Commission appealed against the decision given by the federal court, so they went to the another court. As per the investigation of Acc's, ANZ breached that the duty of care, improper use of information, and duty to act the diligence under the corporation law by fixing the prices. So ANZ breached two laws. One was the corporation law and other was the Competition and Consumer Act 2010. Accc was successful in this appeal against the Flight Center but was unsuccessful in the appeal against the ANZ. The Accc alleges that the ANZ is liable for the fixing of the prices under the Section 45 of the Trade Practices Act 1974. Now it's the Competition of the Consumer Act 2010. The court held that the price fixing appealed to the contracts between the competitors. The ANZ and the mortgages refund were not competitors, so that there was zero chance of price fixing between them. The court also stated that the Section 45A was not applicable on this case because the section says competition may occur between two parties with relevant arrangements. Section 45A applies when two parties having relevant arrangements with two profit centers and there will be two separate entities of both parties. The conditions are not satisfied in the case, so ANZ is not liable under the Section 45A. The decision of the court was clear after the Justice Dossett says that between the loan arrangement service of ANZ and mortgages refund there was no competitive overlap. So our next criteria of the case study is ANZ Accc versus Flight Center Travel Group. Flight Center Travel Group. The Flight Center Travel Group is also related to the fixing of price. The federal court decided that against the Flight Center because according to the full federal code, the Flight Center was in competition with other airlines for the booking services, so there was chances that the Flight Center was engaged in the price fixing. The reason behind the judgment of full federal court against Accc is in the case was that the court was found ANZ was not in competition with the mortgages refund. So without having the competition in the market, the chance of fixing the price do not arise. The reason behind the positive outcome of the Flight Center case was that Accc was confident about the success because proper evidence at the time in Flight Center case. Accc was hoping the court's judgment in its favor, but in this case Accc was doubtful about the favorable decisions of the court. So let's talk about the impact of court's decision on the operating of companies inside the Australia. Price fixing by one company affects the consumer and other companies operating in the same market. For example, if consumer goods are transported by the freight and if there is fixing of price of freight, then it results in affecting the whole chain supply and increases the price of goods. In this way, price fixing affects the market and companies operating in the market as whole. Price fixing is illegal under the Competition of the Consumer Act 2010 in Australia. This decision impacted the other companies. Not only that company, it also affected the other companies operating in the same industry because this competition was not healthy competition, in an impending competition that resulted from the anti-competitive practice between the mortgages refund and ANZ. So I would like to go towards the conclusion. According to this report, the Accc vs ANZ case is related to the price fixing. Price fixing is an illegal activity as per the Corporation Law and Competition and Consumer Act 2010. The decision in this case was against Australian Competition and Consumer Commission in the favor of ANZ. Accc is unsuccessful in its allegation because there was no evidence for such price fixing with Accc. This was the major factors behind the failure of Australian Competition and Consumer Commission. Accc was unable to prove the mortgages refunds and ANZ were the competitors for the loan arrangement service. Australian Competition and Consumer Commission fought two cases of price fixing against the Flight Center and ANZ. Accc succeeded in its case against the Flight Center because at the time the court had sufficient proof that Flight Center and other airline service were competitors in the market. One thing that needs to be focused in this case is the careful consideration should be given in the evidence. Thank you.